All right. Good afternoon, everyone, and welcome to today's webinar, Witness Intimidation Part 2, Effective Use of Intimidation Evidence. Today's webinar is hosted by Equitas. My name is Mary McLeod, and I'm an Associate Attorney Advisor at Equitas, and I will be moderating today's webinar. If you have questions during the presentation, please enter it in the chat box. We will answer questions at the end of the webinar with time permitting. You are also welcome to contact us directly at any time to follow up on today's presentation, and we will send you the contact information to do so. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link is available on our website. Today's webinar is supported by the Department of Justice Bureau of Justice Assistance. The information presented in this webinar does not necessarily reflect the views of BJA. Presenting our webinar today is Equitas Attorney Advisor John Wilkinson. John presents on trial strategy, legal analysis and policy, and ethical issues related to violence against women at the local, state, national, and international level. Prior to working with Equitas, John was the program manager for the Gun Violence Prosecution Program, Homeland Security Program, and Southwest Border Crime Program of the NDAA, where he traveled extensively throughout the US presenting on gun and gang violence and Homeland Security issues. John was previously an assistant Commonwealth's attorney in Fredericksburg, Virginia, where he prosecuted gun crime, drug crime, domestic violence, sexual violence, and was a member of the sexual assault response team. I will now turn it over to John.
Thanks, Mary. And good afternoon, everybody. And thanks for joining us for this presentation today, where we're going to talk about the effective use of evidence of intimidation. On Friday, our colleague Chris Hammond from the Prosecutor Center for Excellence did an overview of intimidation and considerations that everyone in the criminal justice system should be thinking about when they're trying to respond to intimidation. Intimidation is increasingly a difficult crime to deal with, and it's something that we have to think about collaboratively. So we need every player in the criminal justice system to play their part. But we also want to think about it strategically as prosecutors as well, and how we can navigate that legal landscape when intimidation is occurring. So we want to be thoughtful about how we protect our victims and witnesses, how we use evidence of intimidation effectively during trial, and how we can keep the process going, even if witnesses are unable to participate in the trial of a case. So what we're going to achieve today, we will be better able to educate our judges and juries about the latest tactics defendants use to intimidate witnesses. It might be important to explain how defendants and their allies are getting at the witnesses and the victims in our cases today, because it's not the traditional stuff that we might have seen before, or that may still be going on, like going by somebody's house or calling them and threatening them, or saying words that they know are a threat. Increasingly, it seems like intimidation is occurring online via social media, in other ways that offenders can get to the witnesses no matter where they are. So if they can't physically be in their presence, they can virtually be in their presence, threaten and intimidate them. We want to protect our witnesses throughout the course of the case, including the investigation, the discovery process, and trial. And so we'll talk about the legal tools related to that. And then we will also want to file and argue compelling motions to admit the statements of witnesses that may be unavailable for trial. So if the intimidation works and our witness doesn't show up or is afraid to come to court, and can't testify, even if they do, then what are some ways that we can get statements into evidence regardless? And so we'll talk about all of those things. So, and I think Chris covered a good bit of this, but what is this intimidation? This is from a field guide on intimidation that we developed. And it's basically, intimidation is anything that is done with the intention of preventing, altering a witness's testimony or report to law enforcement, or to retaliate against a witness for such testimony or report. And so that retaliation might be to prevent future witnesses from reporting to law enforcement or testifying at trial. So it can be anything, and perpetrators do a wide array of things to get at their victims and get at the witnesses of a crime. So who is doing the intimidation? Typically, we think of the perpetrator of the crime doing it, but they're not the only ones. Sometimes it's their colleagues, their allies. It could be a fellow gang member, members of a gang that go after them. It could be a family member in a domestic violence case that makes it difficult for the victim to come forward. Sometimes it's unintentional. Sometimes it's very intentional when family members are doing this. Sometimes the system can be intimidating to victims and witnesses. And so we want to make sure we do everything to make the system acceptable to them so that they aren't afraid to come forward. And if they are afraid, that we can calm their fears or reassure them about what it is we can do or what we think will happen in this case. What do? They commit all sorts of crimes to cover up the crime that they've been identified for. And it could be simple threats. It could be up to assaults and property damage and homicide even. So they do it. When they do it, immediately it starts immediately after the crime. Sometimes it starts even before the crime occurs in neighborhoods where the stop snitch mentality is so sewn into the fabric of the neighborhood. People know if they contact the police, there's likely something going to happen to them, or they're afraid something's going to happen to them, whether that's likely or not. A lot of folks that we work with in police departments around the country, prosecutors' offices around the country, say it's more the perception of retaliation than the reality of retaliation. People are afraid something's going to happen to them, even when there isn't really a high risk of that happening. In some cases, there is a risk of that happening, and we have to be careful as we assess this and make sure we do that thoughtfully and in an evidence-based way. Often it is just the perception. I talk to the police and I live in a neighborhood, people are going to come after me because I talk to the police. So that happened in an ongoing fashion. But anytime after the crime and leading up to trial, folks will go after witnesses. And even after the trial, we've seen folks go after witnesses after the fact, or their allies have gone after it. And it can happen anywhere now. Typically, we think of things, people going by one's home, it occurring in school. If you're going to school, it occurs at the workplace. Going to and from places could happen at a social gathering, but also increasingly it is happening online. So the perpetrators know I can get at this victim or witness anytime I want. There's nowhere for them to hide. I can do it through social media, through email, text, however. So that's happening. How they do it, they use all the tools at their disposal and send messages. Sometimes they're veiled threats. Sometimes they're open threats. Sometimes they're words that only that victim would know, that don't seem like a threat. But for example, a victim might find a bouquet of roses on her front doorstep, and she knows that her abuser said, the next time you see a bouquet of roses on the doorstep, that's the day you're going to die. Something like that. Could be in a gang case that a detective was telling me. We have witnesses in our gang cases who are walking down the street and someone they've never met before comes up to them and says, "How's your mom doing?" and then walks off. And that person knows or strongly believes that is a threat against them, their family. So they do all sorts of things. And of course, why is they're trying to evade detection for what has happened to them, evade accountability. So they're hoping that that's it for that witness. And it also could be to send a message to people who might be also witnessed in that case, or future witnesses if someone is engaged in ongoing criminal activity, say in a gang situation in a particular neighborhood or a group situation. We're seeing gangs sort of transform more into loosely associated groups and less in the formal gangs that we've seen in the past. And it depends on what jurisdiction you're. Some still have those hierarchical gangs and classic gangs. Some have affiliates and some have just groups that have started up. So it just depends where you're at. So where do we see intimidation? Usually where we exert little control. The police, government exerts little control. So people at home, going to school, work, things like that, running errands or socializing. But we also see it happening in places where we do exert control, like it could be at the police station while someone's making a statement. If anybody's had a victim whose phone is blowing up with text messages because a perpetrator is trying to get at them saying, "What are you doing? What are you saying? Where are you?" Things like that. It could be somebody in the courthouse. They're waiting to testify. It could just simply be multiple members of a gang show up, or a group show up at court and sit in the rows in court and fill the room as that person is having to testify. And of course, it happens while people are on the witness stand itself. And I've had that happen in my cases as well, where alert courtroom deputies came up to me and told me what was going on. And we got that person out of the courtroom and alerted the court to what's going on. So these things happen, and our response needs to anticipate this and be ready for those things to happen. And so our response has to be collaborative, because this is happening everywhere. It's happening in those places we don't control. So how do we ensure the victim's safety in those areas? And it happens in places we do control. Those places, how do we beef up our security, beef up our observation to make sure that witnesses are safe in the courthouse, in the courtroom, at the police station, whenever they're engaging with the system? It sends a terrible message if intimidation is allowed to happen where a judge is, prosecutor, police, bailiffs, court clerks, victim advocates, right in front of everybody. If witnesses' intention is happening, that sends a terrible message to that witness about our ability to keep them safe as they go through this difficult process. So those are all things we should be thinking about on an ongoing basis, and think about how do we improve our response to the problem of intimidation. The most dangerous time for a witness to testify is between arrest and trial. This is from a study from 1995. And the second most dangerous time was during the trial itself. So between arrest and trial, as the trial is coming up, that's when efforts to intimidate a witness are going to ramp up. They're going to start trying to get a witness, because they know if that witness is still engaged in the process, then they're coming to court to testify. And so they'll do everything they can to stop that from happening. But as we know, it happens during the trial itself, and that's the second most dangerous time, according to the 1995 study that was done by NIJ. And I really like this. It's very simple, but it kind of puts into clear context what's going on there. Only unsuccessful intimidation ever came to the attention of police or prosecutors from the 1995 study. So if it's successful, we don't know about it because the victims and witnesses are afraid to come forward. When it's unsuccessful, that's when they might tell us about it. The other problem is victims and witnesses don't always know that they should share what's going on with police prosecutors with regard to intimidation. It might be part of their day in, day out life. It might be because of the neighborhood they live in. It might be because of the relationship they're in, that this is how their life is. So they might not realize it's important to share that with the police and prosecutors, because there are things we can do in response to intimidation to make that witness safe, and that evidence intimidation or efforts to intimidate someone valuable evidence in the case itself. And so we want to make sure that we proactively ask about intimidation as we move forward in cases and document evidence so we can use it to our trial. And we'll talk about some of the ways we can do that. So some of the challenges and some of the things we need to think about is, one, can we reduce opportunities to intimidate? Is there a way that we can identify places where victims and witnesses are intimidated and reduce those vulnerabilities, those opportunities? And we can do that. One would be by assessing our physical structures at courts, how people come and go. and where people have access to victims and witnesses. And what crimes do we anticipate that there to be a high probability that intimidation is going to happen, like gang and gun crime, like domestic violence crime. Those crimes tend to be the ones that we see a lot of intimidation in. The intimidation is the bread and butter of the gang involved or group involved criminal, and it is the bread and butter of the domestic abuser. And so when we have those cases, we should be particularly concerned about intimidation. But intimidation can happen in any case, so we want our eye on the ball and be proactive in asking victims routinely, has anybody contacted you? Has anybody made you comfortable coming to court? Has anybody suggested you not come to court? Things like that. Asking questions regularly our victims and witnesses to make sure nothing is going on. We also need to educate victims about intimidation and witnesses too, because they're likely to have the evidence of intimidation, but they may not realize its value or its importance. And so they may not recognize they should turn that over. Victims who get nasty voice message from their abuser or nasty text messages, it's understandable that a victim might want to delete that immediately, but that's important evidence. That is something that I might be able to use at trial that might demonstrate a consciousness of guilt on behalf of the defendant. It might demonstrate a criminal charge of witness tampering or obstruction of justice, depending on what my code section like in my jurisdiction. And so I need to have that information. It might support option for forfeiture by wrongdoing. And so we want to about victims are the ones and witnesses are the ones who are likely to have that evidence, and we need them to let us know anytime something happens that they should turn that over to us in case they don't know. Some victims are very good about contacting police anytime anything happens. Others are not. They just think, that's how he always talks to me if I'm a victim of domestic abuse. He always threatens. He never does anything, so I'm not going to worry too much about it this time. We need to know that just because it'll help the case. We want to keep victims safe because we never know it precisely when someone is going to cross that line from or maybe routine pattern of abuse to an inflated pattern of abuse or even kill a victim. We should preserve the evidence of intimidation. So if someone gets a voicemail or text message that is a threat of some sort or some sort of communication via social media, we want to, as investigators and prosecutors, preserve that evidence. Take a screenshot, download it, somehow get a picture or photograph of, and preserve that, and then we'll use that to our advantage in our case. We also to charge intimidation crimes, and that is something that does not happen quite a lot in a lot of jurisdictions. Some jurisdictions do keep their eye on that ball, but even when they charge intimidation, charges don't always tend to go through. It might be a throwaway charge or something that is lost in the shuffle. So we should charge intimidation crimes and try and marry them up with the original crime if possible, because they become more powerful together than apart, if that's possible. It may not always be possible, but if you can do intimidation that occurred after the original charge was placed or the original crime took place, then that's even more powerful. And we want to use the evidence of intimidation effectively. And I rattled off some of the ways we do that. It could demonstrate a consciousness of guilt. If you didn't commit this crime, why are you trying to prevent this witness from testifying? It could be the basis for a motion forfeiture by wrongdoing. And that forfeiture by wrongdoing is the legal theory that says if I can prove that the defendant did something to make this witness unavailable, not come to court, not change their testimony, but refuse to testify, things like that, and I can show that was their intent, then I can introduce absent witnesses or that witness who's refusing to, I can introduce their statements into evidence. And we'll talk about that in detail. It might also enhance sentencing. You could make a good argument that not only did this individual commit this crime of violence or whatever crime it is, but then they committed another to cover up the original crime. And that is deserving of an enhanced punishment because that's particularly egregious in circumstances. So we're going to talk about some strategies that we can use, legal strategies, to improve our ability to go forward when we are trying a case that involves intimidation. And one of the strategies we want to use is identify and document non-testimonial statements. And those are non-testimonial hearsay statements, out-of-court statements from the victim or witness. And we'll talk a little bit about what that means. What is a non-testimonial statement and what are we talking about here? So the Sixth Amendment to the United States Constitution gives every criminal the right to confront and cross the witnesses against him or her. So everybody has that right. But what does that mean precisely? Does that mean anytime somebody is a witness, no matter what they said, under any circumstances, they have to come to court and testify about that? Or are there differences? And the Supreme Court did divide things up, out-of-court statements, into two broad categories. One is testimonial and the other is non-testimonial. Testimonial hearsay, those are generally more formal statements that are typically made to, say, law enforcement or other government agents or folks working on behalf of law enforcement. And the primary purpose of those statements is to report facts for later prosecutions. So you can imagine the typical law enforcement officer, give me the facts, just the facts, and taking them down and going to investigate that case and are taking these statements so that they can mass a case to prosecute someone for a crime that they've committed. So that's a classic testimonial statement. Testimonial hearsay under the Crawford v. U.S. case back from 1984 is admissible only where the declarant is available for cross-examination at trial. So the witness, the declarant is the witness, they're present and available for cross-examination at trial. And it's testimonial hearsay, something that they said outside of court about what happened. They have to be in court if it's testimonial, and they have to be subject to cross-examination. Or if we can show that the witness, the declarant, was unavailable to come to this trial, but defense had a prior opportunity to cross-examine them about this issue previously, that prior testimony where the cross-examination can come in. And then the other category where testimonial hearsay can come in is that legal theory of forfeiture by wrongdoing, where the defendant has literally done something to cause a witness to become unavailable. And typically we think about things like threats or violence, things like that, but it really could be anything that's designed to make that witness unavailable. And so we'll talk about that in more detail later. And if we can prove that, those statements can come in, even if they're testimonial. But testimonial statements, typically the witness has to come to court and testify, or at least they have to have previously come to court and been subject to cross-examination. And again, these are those statements that are formal, made to law enforcement, and the statement is made really so that you can prosecute somebody later on. So that's those testimonial statements, those classic law enforcement interviews. So what are non-testimonial statements? Well, starting from the bottom of the screen going up, they're casual remarks to others. So you can imagine someone might tell a friend, family member about a incident where they're a victim of a crime. You'll never believe what happened to me. Just a half hour ago, somebody put a gun on me and took my wallet, something like that. So they're telling that to somebody they immediately saw shortly thereafter. They're not telling that other person, assuming it's not law enforcement, just some other they met, a family member, friend, something like that. To get that perpetrator prosecuted, they're just telling them about what happened. Business records that are not prepared for litigation purposes are non-testimonial. So we'll often use business records to prove elements of a crime. And so those are non-testimonial. They're kept in the usual course of business. They're not kept for the purpose of having somebody prosecuted. Certain business records, though, such as a certificate of analysis in a drug case, that might be something that is produced at your state lab when they analyze drugs and is kept in the routine course of their business. That would be considered testimonial, and that analyst is likely going to have to come to court to testify about that unless your state has a statutory scheme to avoid that. Sometimes defense is required to request the examiner come to court before they're automatically made to come to court. Statements that are made for purposes of a medical treatment. So that when we're treating victim of crime, the medical folks are typically not treating them to collect evidence for trial to have somebody convicted. They're just trying to treat the injury that they're presenting with. And there's some tricks to that, and we'll talk a little bit about that in a minute. But that's a classic non-testimonial hearsay statement, depending on how your system works or how your medical professional operates. And the last one is the statements during an ongoing emergency that are made to police. And so 911 calls are typically non-testimonial. Here's the rationale behind that. It's basically that these statements to 911 are not really to prosecute somebody later on. They're typically made because you're in the middle of an ongoing emergency and you're trying to get help. And so that's the rationale that the courts use for statements to police during an ongoing emergency. That the primary purpose of those statements is for that individual to get help or to aid the police in meeting that ongoing emergency. It is not to prosecute them, even though that may be secondary purpose that we'll often use statements made during a 911 call, or when law enforcement show up to the scene of a crime, or shortly thereafter, say a domestic violence crime scene, and the victim runs out of the house. He's inside, he's got a gun, something like that, and identifies who she's talking about. Those statements are made to get that victim help and to aid the police in meeting that ongoing emergency of the armed gunman in the house. And so that's their primary purpose. And the courts have said those are actually non-testimonial statements. And that means that if it's a non-testimonial statement and the victim or witness or declarant does not have to be at court. There is no Sixth Amendment confrontation right for non-testimonial hearsay. That means the defendant does not have the right to cross-examine the declarant, the victim or witness who made those statements at trial. However, there is a requirement that there be some hearsay exception to get those statements in. And so subject to whatever your state's hearsay rules are to get those statements in. So not any statement a victim or witness makes outside of court that is non-testimonial is automatically admissible. The defendant doesn't have the right to confront the witness, but there still needs to be a hearsay exception to get those statements in. And so we have to look for those hearsay exceptions. Think about ones that are going to lend themselves to these types of situations. So for non-testimonial hearsay, we want to think broadly about who the witness might have spoken to beyond law enforcement, beyond whoever they spoke to. Not every criminal case starts out with a call to 911 or talking to an officer at the scene of an emergency. Such those statements might be non-testimonial because they're meeting an ongoing emergency. We have to think about who else a victim or witness may have talked to. So think about what friends or family have you talked to? What employer, coworkers, your landlord, neighbors, who else? What other professionals may you have talked to? Whether it's healthcare professionals or other professionals that you happen to share what happened to you. Statements to these individuals are highly likely to be non-testimonial in nature, and therefore the defendant doesn't have the right to confront the declarant. However, there still needs to be a hearsay exception. So one of those exceptions would be to healthcare professionals. And this is the federal rule of evidence that covers statements that are made for the purpose of medical diagnosis or treatment. And those statements are typically non-testimonial, and there's an exception to them. And the reason is that we believe these statements tend to be accurate because people want to get proper health care, so they tend to be honest with their physician, their nurse, their PA, their healthcare professional that is helping them out with whatever is ailing them, even when they're a victim of a crime or an assault of some sort. So that hearsay exception allows for statements that are made for and are reasonably pertinent to medical diagnosis or treatment. And it describes the medical history, past or present symptoms or sensations, how they came to be, their inception, or what their general cause was. So it gives a little leeway there into what you could ask about, what a physician could ask a patient about how their injuries occurred. The classic thing, though, the classic defense will be the doctor doesn't need to know who gave me the black eye for the physician to treat my black eye, right? The physician might want to know, did somebody hit you with something? Did somebody hit you with their fist, with an object? glass, something to treat it. But do they need to know, yes, and it was my spouse, or yes, and it was my best friend, or who it was particularly? So that's going to be the classic defense. And the court responded sometimes in favor of the defense, sometimes in favor of the prosecution, depending on the circumstances. And so we have to think about when we would be able to get the identity of that assailant in through medical examination. So this might be in a classic domestic violence situation where our victim has not come to court or refusing to testify, and we need to somehow identify who the assailant was without the victim. And it might be that they identified them to the medical provider. But the big question is going to be, is that going to be allowed to come in via the medical hearsay exception for purposes of diagnosis and treatment? And it's really going to depend on the facts of your case. This is a case out of Louisiana from 2015 where they talked about, particularly for domestic violence cases, that the person who is the perpetrator is kind of part of that physical examination now, that healthcare examination, not physical examination, but that healthcare encounter. And these statements are non-hearsay pursuant to this medical hearsay rule, and are therefore admissible as substantive evidence because they were made for purposes of diagnosis and treatment. And that essential components under current medical practice in cases of domestic violence, not as part of a forensic examination intended for use at trial. So what they're saying is that it currently, we treat victims of domestic violence when we're treating their physical injuries, we go a little further and we want to make sure that they're safe, not just physically, but also emotionally, psychologically, and knowing who the perpetrator was who gave that black eye is going to help that physician treat that whole person in multiple ways. As a healthcare provider explained it to me one time is, I need to know what that patient is going home to. So if a patient were on crutches, I would ask, do you have stairs in your home? Because it's dangerous to go upstairs on crutches. Is there one level you can live on? Now, normally you wouldn't expect a physician to have to ask that to treat a broken leg or something, but they're asking that because it's a common concern and they need to know it. It's just like the victim of domestic violence. If they're sending them home to the abuser, then they're going to provide them with different resources. They're going to here's a shelter resource. Here's the DV hotline number. Here's someone you can talk to. Here are places you can go to get counsel or to get shelter if you cannot go home. And that is all part of that healthcare encounter now, and is made for purposes of diagnosis and treatment, not really to get the offender prosecuted. And so in this case, in Louisiana, they allow those statements in. That's not going to happen in every case and in every jurisdiction. It's going to rely heavily on the foundation that the prosecution is able to lay about that medical encounter. If that medical provider can't say, I ask these questions for routine medical purpose, it's for my discharge planning. I might say you need to follow up with your regular doctor in next week, and you need to maybe explore shelter or talk to a DV counselor. That's part of our routine treatment in these cases. Then that's likely to be able to come in. It also is contingent on why the patient, who is also the victim of the crime, is telling the healthcare provider this. If the patient is telling you to get proper healthcare or is understanding that they're being asked this so that they get proper healthcare, that also will help the admissibility of those statements. If those things are absent, a court might say, no, you can't introduce those statements in these cases because you did explain how this is related to the healthcare encounter. It just appears to be the physician trying to help the prosecution go forward by asking these questions, or when they ask them that there was no clear medical purpose going on there. This is a case from Maryland that was related to sexual assault. Now, typically sexual assault cases, we're probably going to have our victim present, but it's also helps the case if we're able to introduce additional times that the victim identified the same suspect as our assailant. And a lot of times, domestic violence cases, we also see crossover sexual assault by the abuser. And that's a big red flag of danger when we're doing danger assessments for those victims. But it happens a lot. We don't always discover it because people are reluctant to share that. And when we're more active about asking about that in domestic violence interviews, we might get more responses about sexual violence that has occurred there. But in this case, in Maryland, back 2003, the court said, we agree with the state and the trial court that a sexual assault victim statement describing the assault may be admissible under Maryland's medical hearsay exception, even though it was taken and given for dual medical and forensic purposes. So typically, if you're the victim of a sexual assault, you would go to a sexual assault nurse examiner or a sexual assault forensic examiner who's going to treat the injuries that you might have as a result of the sexual assault and also collect evidence for the police in those cases. And that forensic side of the often causes courts to say, no, evidence collection, pure and simple, that's not for diagnosis and treatment of a patient. That is really to help the police and the prosecutors prove their case. But a lot of courts have said, no, if you can demonstrate you're asking these questions for a legitimate healthcare purpose, it doesn't matter that you also happen to collecting evidence. The primary purpose is for medical treatment, then those statements can come in, even when you're collecting forensic evidence. And so if you're concerned about where your state falls in that those arguments, please reach out to us and we can do some research for you very quickly and tell you what your courts have said so far on it, and then maybe provide you with persuasive case law from federal courts and other state courts that have allowed this to come in to equip you with making that argument if you need to. Just because a court hasn't allowed those statements in previously, that just may relate to the foundation in that case that by those prosecutors to introduce those statements, and that the foundation simply wasn't there based on the evidence that they had at the time. You might be able to do a better job getting that foundation laid now that we have a little more guidance. So please reach out to us on that. Here's a good question that we should be asking victims of crime, particularly crimes in group violence, domestic violence, the crimes that we know a lot of intimidation is associated with. We want not just police, but prosecutors, victim advocates, anybody can ask the victim this. And that is, have you talked to anyone else about this incident, either before or after you spoke to the police? And so you can imagine the situation might be a victim of a crime, a violent crime, calling 911, asking the police to come for help, or calling the police at some point, or flagging down a police officer and telling them what's happened. But a lot of times our victims will, particularly domestic violence victims, will reach out to a friend or a family member and say, you can't believe what he did to me this time. They encourage them to call the police, and then they call the police. Or they call the police, and then they call that family and friend for support afterwards. And it's not just domestic violence. A victim of any violent crime would naturally reach out for support to their loved ones, or a trusted friend. And so those people are going to be non-testimonial hearsay witnesses. They're not calling their friend or their family member to get someone prosecuted. They're calling them for support. And if it happened right around the time that the incident happened, or that they called the police, which is usually right after the incident happens, then the hearsay exception it's tied to is the excited utterance. And so that's why this is a good question to ask somebody, not just at the scene of the crime, but anytime later. Hey, I know you called 911 on this date. Did you have to talk to anyone right before you called 911 or right after? Or if they didn't call the police right around the time of the incident, just ask, right after this happened, did you talk to anybody about what happened to you? So if they did happen to reach out to a friend or family member about a violent assault that was perpetrated against them, but they didn't call the police for days or weeks, then we could still get those statements in from that friend, because it'd be close in time to the assault. As long as it's close in time to the assault, it would be an excited utterance. So we want to think about those things and document that evidence of any ongoing emergency at the time. So it's got to be close in time to the incident that caused the excitement, the assault, and we often relate that to the police. So if you talk to anyone before you call the police or after you call the police, or talk to anyone right after the incident happened, if you didn't call police, let's document those statements, document the identity of the person that said to. So if I don't have my victim witness at trial, I can maybe get that statement in through that other person. It'd be non-testimonial, and the hearsay exception would be the excited utterance. Another strategy is to charge intimidation crimes and join them with the principal charge. And these are just a random example of some of the charges that you might see: public intimidation and retaliation, intimidating or impeding witnesses, obstruction of justice, suborning perjury when abusers try and get their victims to change their story or lie. So those are some of the things we should be charging. I see that we have a couple of questions, so maybe I'll just try and answer these before we move on too far. In these instances where we are able to introduce the statements in the medical records, is it required that the victim also testify? Must she be unavailable for these statements to be admissible? For the medical hearsay, the medical hearsay exception is regardless of whether the victim is available or unavailable. So it can come in even if the victim is testifying, and it can come in if the victim is unavailable, and not testifying. So that's the typical one. You can look up your hearsay exception if you shoot me an email. My contact information at the end of the presentation, and then you can always reach Equitas generally. But typically, it is regardless of the availability, the witness, the declarant, that should have can come in there. And then there should have been an or in between those questions, and that's probably referring to the previous slide. So thank you for that. And this, of course, occurs by text and social media as well. And yes, that's a great observation. It's just in person or reaching out to somebody by phone. You can reach out in other ways, and that is to be as valuable as well. Let me get rid of that. Oops. All right. So we covered that, and you're right. Either before and after you asked that, because we want all those witnesses, not just the witness who you talked to before. So make sure you do that. How do you survive a motion for severance if you join these? You may not be able to, but I think what I would argue is that these two crimes go hand in hand. So a motion for severance would be, hey, this other crime that you've charged my client with is really unrelated and would be prejudicial to try them together. And that's the point that they're making. And you may not be able to. I think you could make a solid argument that they're tied closely together. The whole motivation behind this second act of intimidation is because of this first act of assault, or what that crime may be. And so a court leans toward judicial economy, where that we're trying to do things in a simple way and try cases together that belong together. But a court might easily, as you say, no, that's just going to be prejudicial to throw that in there. I think it's completely relevant. And I would argue to the court that, fine, judge, but I'm going to bring in my case in chief the evidence that this individual intimidated or attempted to intimidate my victim and witness, because that's relevant as consciousness of guilt. There's no reason for him to do this if he is innocent, and the jury can infer from these acts of intimidation that he is guilty. So you can keep separate, but you're going to hear all the evidence, say evidence twice, and argue with that. Now, if your judge says, no, I'm not going to allow you to bring that evidence in, then you're stuck. But those are some arguments you can make. Okay, so some of the things that we should think about when we want to protect our witnesses are, what do our criminal codes allow us? So Louisiana code has a number of things that I pulled, and a lot of jurisdictions have these provisions. So it could just be protection of the witness's identity in, say, a violent gang case. Obviously, in a DV case, the perpetrator is going to know who the victim and witness is typically. But in a violent gang case or group case, maybe we want to protect that with for a protective order, where we do not have to disclose that witness's identity until right up against trial or at trial itself. And we asked the court to allow that to happen. We're going to have to support a motion to protect the witness identity or redact discovery with that information. And so we're going to have to demonstrate why we believe that is necessary, because that might be an extreme measure in the eyes of the court. So make sure you've documented everything that has gone on with regard to that witness so that we can make a strong argument in court that we should not have to turn over this witness's identity in the routine course. We're going to ask that it be delayed or right before trial. And the statute in Louisiana basically says that you have to demonstrate information why you believe. And it's not just the prosecution that can do this. The defense can do it too. And when we talk about intimidation, it's typically the prosecution witnesses who are at threat of being intimidated by defense witnesses. Always the case. Defense witnesses can also be intimidated. There are gang-on-gang violence, group-on-group violence, where people go at and then try and intimidate one another, whether they're charged with the crime and going to support what the defense has to say, or whether they're cooperating or testifying on behalf of the prosecution. But you have to be able to demonstrate why you think this person's in danger and why you need to withhold that information. Redacted discovery, same sort of thing. This is also a case from Louisiana, where they laid out a scheme and a principal scheme for how you can say that, how you can argue that you do not want to turn over all the discovery. And so what you would have to do, if the defense is saying, hey, you redacted this information about the witness, their address or their name or their some identifying information, and I will talk to and interview that witness, say, no, I can't turn it over to you. I'm going to argue to the court in an expert hearing why I don't think you can do that. And we can tell the reasons why this person is threatened, or we think they're threatened, or the history of threats that this particular defendant has done to other witnesses who have attempted to appear before him. And then they keep those court reporter, and it's recorded, and they keep the record sealed and redacted with the court, and it is reviewable. If the defense feels like they're not getting a good deal, then they can appeal that to a higher court, and that court will have that sealed record, and they can make a decision based on that record as well. It has to have some sort of court review in Louisiana if the defense requests. Now, if the defense does request, you redact, and they don't request the information, you're okay. If you're curious to know what the scheme is in your state, reach out to us, and we'll do the research for you. And then there's restricted discovery also in Louisiana and other jurisdictions as well. And basically what this was, they really didn't redact anything. It was a sexual assault case, and there was a lot of information in there and maybe some photographs and things. All the prosecution said was, we're turning all the discovery over to the defense attorney, but we're asking the court order that he not just copy that discovery, give a copy to his client, that he only share it with him in person, and they talk about it, and then he keeps control of it. So that this individual was in jail. We're concerned that information about that victim would be circulated throughout the jail, and then maybe outside of the jail, and then maybe onto social media and things like that. And so the defense objected, and the court said, "Oh, I'm going to allow have everything. You can't have a physical copy yourself." And the court on appeal said, "Look, the defense really didn't show any way that they were prejudiced by not having been given an actual copy of all the discovery he had access to when he met with his defense attorney." Now, there might be situations that are a little different where the court would say, think of like body-worn camera footage. I mean, that you might want to have to look at that for quite some time, and you might want your client to have a copy of that. I don't know. There are other things that you can do when you're turning over discovery that is being restricted or under a protective order by the court to be shared. A lot of jurisdictions are now adding a defense copy and a watermark on any documentary discovery that they turn over. And whether that can be done on a video as well, I don't know. But things like that, so that if it does wind up on Facebook or somehow shared socially or in other ways, we'll know right where it came from. Think about those protective orders, restricting discovery so that we do a better job protecting our witness and preventing things from being released to others and to the community. Another strategy, we want to preserve testimony with the opportunity for cross-examination. So because one of the exceptions to the testimonial rule, the rule that if it's testimonial, say the defendant, or I'm sorry, the declarant has to be present and testify, think about opportunities that the declarant can testify prior to trial, be cross-examined, so that preserves that testimony for later use at trial if for some reason our victim or witness becomes unavailable. So it could be from a prior trial, or it could be a preliminary hearing where you're going to record that testimony at preliminary hearing. We're going to provide discovery to the defense ahead of time so that they are prepared to do a full and fair cross-examination. And we're not going to object like we might have a normal preliminary hearing. We'll let the defense go a little further so they have a full and fair opportunity for cross-examination at a preliminary hearing. Sometimes defendants seek to waive preliminary hearing, and so an argument we used to make was, the defendant has the right to have a preliminary hearing, but they don't have the right not to have a preliminary hearing. So if they're essentially trying to waive the preliminary hearings, they're confident they'll be able to get rid of a witness or make our witness unavailable come trial time, and you feel like there's a opportunity for this victim or witness to be intimidated and threatened, then you might want to get this testimony down at preliminary hearing and sort of argue to the court, no, we want to do this for various reasons, and we'd like to go forward, and we provided discovery, and they have a full and fair opportunity to cross-examine. So we do want to think about that. And fight their attempts to waive. We'll pass discovery before the hearing. I'm sorry, there were a couple others there. Grand jury proceedings do not afford an opportunity for cross-examination. That here's the testimonial statements in grand jury proceeding, or those be considered testimonial rather, are not going to be able to come in under this idea that the defendant had an opportunity to cross-examine them. And then depositions may or may not. Some states have criminal depositions, and it just depends on the state whether their criminal deposition rules would consider these things to be prior opportunities for cross-examination. At preliminary hearing, we talked about this. We'll pass discovery before the hearing, refrain from objections to the extent possible, give them that full opportunity, fight attempts for them to waive it. Okay, then the last strategy, or one of the last strategies, is forfeiture by wrongdoing. And that concept is that the defendant has the right to confront and cross-examine the witnesses against him or her. The right can be forfeited if the witness cannot be confronted due to the defendant's intentional wrongdoing. It's basically just saying, hey, you can't insist on your right to confront and cross-examine somebody when you've made that witness disappear. Sort of like a clean hands doctrine, or just sort of a equitable remedy, that you don't get to cause the witness to go away and then say, hey, where's the witness? And so the three things you have to show to get statements in under a forfeiture by wrongdoing is that, one, the victim is unavailable, two, that the defendant did something to cause the victim to be unavailable, and we call that wrongdoing. But think broadly when we say wrongdoing. There's a case out of Massachusetts where the defendant married the victim to make the victim unavailable in a domestic violence case, and Massachusetts doesn't have an exception to spousal immunity where in a domestic violence case, like many states have. In child abuse and domestic violence cases, there is no spousal immunity, but Massachusetts still has that. And so the defendant knew that and deliberately married the victim to avoid her being able to testify against him. And the victim shared that with her sister, who was like, why are you marrying the guy who just beat you? And she said, it's the only way to prevent me from testifying against him. And so the court said, nope, that's wrongdoing, because it was intended to prevent that witness from testifying or prevent evidence from coming in. And you have to prove that the defendant intended that result, that they were trying to make this witness unavailable. So the victim's unavailable, the defendant intended them to be unavailable when they did what they did. So if there's no evidence that that was their intent, then it may not come in. But usually the circumstantial evidence should provide that. Forfeiture by wrongdoing, this is the federal rule. Multiple states have this rule of evidence. Many states do not have a rule of evidence, but they have case law on it. And then other states do not have any case law or a rule on it. But every state that has examined forfeiture by wrongdoing has approved of the rule. Do you have the citation for the Massachusetts case? I don't have it. The name of the case is Serlong, I believe, and I think it's Szerlong. So it's kind of an unusual name, and you should be able to find it that way. I don't have it off the top of my head, but if you email me, we'll get you the exact case on it. Okay. Oops, did I skip too far? Okay, so here's the rule, the federal rule. Everybody who's looked at this has said, yes, forfeiture is legit, including the Supreme Court. The federal rule is a statement offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability as a witness and did so in that. So those are the three things. The witness is unavailable. The party that is offering it, or it's offered against the party that caused that witness's unavailability or acquiesced in wrongly causing it. That's important when you have third-party intimidation, acts by third parties, and the idea there is the defense going to say, well, I didn't do that, somebody else did. So it covers that situation. You're still going to have evidence to show that they did it on his behalf with his acquiescence and that they intended that result to make that witness be available. So that's the federal rules on forfeiture by wrongdoing. Most state rules follow this in form and fashion. There are some rules that are a little different and a little unusual. Some are unusually good, some are unusually bad for the prosecution. So if you want to know what your state's rule is, just let us know, and we'll tell you if they have a rule or not, or what the case law is. And we also have on our website a pretty good primer on forfeiture by wrongdoing that you can access anytime. It's like 8 or 10 pages. It lays out the basics of forfeiture by wrongdoing and a lot of the federal case law and some state case law about it. So check that out. It would make the basis of a deep brief if it's the time your judge is considering the question of forfeiture by wrongdoing. So it applies to any potential witness who is unavailable. So any witness or a potential witness. So there's some cases where a lot of them are drug cases where there's a confidential informant, and the confidential informant, when they learn he's informing, is murdered. And so they've been able to get the, even though there was no case pending, they've been able to get the statements of the confidential informant in because they demonstrate he was murdered to prevent him from testifying. And it opens the door to any hearsay, non-testimonial or testimonial. So it doesn't matter what that is. Oh, and thank you for sharing the Serlong site, if anybody wants, because it is kind of a specific case, and it kind of expands our consideration of what constitutes wrongdoing. Most people would consider not wrongdoing, but in this case it was. So that's helpful. Okay. And the Giles v. California was the major federal case on forfeiture by wrongdoing that established those three principal elements. As we're running out of time, I'm not going to go through all of what Giles said, but basically they said you have to show those three things: that they're unavailable, the defendant did something to make them unavailable, and the witness, that was their intent. This was also from Giles, that earlier use or threats of abuse intended to dissuade the victim from reporting to outside would be highly relevant to this inquiry, as would evidence of ongoing criminal proceedings. So the existence of a case is going to be very powerful. We also have to show that we did everything we could to get the witness to court. And so make sure that that might go beyond just sending a subpoena to the last known address. You might want to be able to demonstrate other things you did to try and locate that witness. These last questions only apply to New York if you're prosecuting in New York, and New York, their rules of evidence are sort of court created. And they basically said that even if a witness comes to court and recants or changes their testimony, and there's evidence they did so because of wrongdoing by the defendant or the accused, then the original statements can come in. But that's just New York. And so be careful because most states who have a code of evidence, statutory code of evidence that dictates what an unavailable witness is or defines what an unavailable witness is, would probably not include a witness who came to court and testified when they changed their testimony. But New York did. And there's a couple of cases where New York said it's silly to pretend like this isn't an unavailable witness, or at least that their testimony isn't unavailable where the defendant did these things to that witness. So just some general motions practice: motions to admit non-testimonial hearsay, motion to admit evidence under forfeiture by wrongdoing. You can do both of those motions simultaneously. You can say they're non-testimonial hearsay statements, so it should come in anyway. But if you don't buy that, Judge, then here's our forfeiture by wrongdoing argument. So you might litigate those together. And you want to do it ahead of trial so we'll know what to expect come trial. But sometimes you might have to do it at trial, so be ready to make those motions orally. So going forward, we want to recognize and address acts of intimidation, support the victims to enhance their ability to participate at trial, document non-testimonial statements admissible under the exceptions, preserve that testimony with an opportunity for cross-examination, and litigate motions to admit evidence under forfeiture by wrongdoing or under theory of non-testimonial hearsay. This is my contact information, my email address, and our Equitas website, where you can also request assistance via the website. If anybody has any questions or wants some resources or anything along those lines as a result of this presentation, please let me know. And I don't know what I did there. Maybe I can go back one. Yeah, there it is. So if there's no further questions, we're just slightly over time. I want to thank everybody for attending, and please let us know if you have any questions or require any resources. We're happy to do the research for you. There's no cost to you guys. The Department of Justice, the Bureau of Justice Assistance funds us to do things to assist prosecutors that way. And so please reach out to us for that help. Thank you, everybody, for your time and attention.